total. Cause numbers 19-33493, 33494, 33495, 20-34377, 34378, 34867, 34868, 34869, and 34870. All filed the state of Texas versus Mark McCoven Simon. You are Mr. Simon, present with your attorney, Mr. Smith, and the state's attorney. Earlier in this case, you entered some pleas of guilty to some of these cases. I've got 33493, continuing child, 234,867, continuing. There were three.
Yes, sir.
That's the other six cases involving it looks like indecencies and are to be dismissed as part of this plan of the defendant's entry of guilty pleas in these three cases. Is that correct?
Yes, sir.
All right. A pre-sentence report has been prepared on these three cases. Have the parties had an opportunity to review them? Any corrections or changes to it? Not from the state?
Not from the defendant.
Then the pre-sentence report in these three cases of 19-33493, 34867, and 34869, which are pleas to the lesser included made a part of the record without objection. Now, the agreements in these cases are that these are caps. So, in 19-33493 and 20-34867, the defendant is looking at no less than 5 nor more than 40 years confinement in prison in each of those two cases. Then, in that case, the defendant, it's a third-degree felony, and he's looking at no less than 2 no more than 10 years confinement in prison. And the agreement is a 40 years sentence shall be no more than 40 years confinement in the no more than 10 years in 34869. But we're all in agreement. That's the statutory cap anyway in that case. Okay. All right. The court has reviewed and I see I've made highlights on a lot of the things, and beginning with 33493, this is an event that was continued over a period of time from on or about October 14th, 2017 to January 17th, 2019. So we're talking about there about a year and 4 months.
That's the allegation.
As alleged. And the victim in this case was the defendant's daughter.
One of the victims was the defendant's daughter. Well, another victim was the daughter of an ex-girlfriend, I believe.
No, I'm talking about in 33493, it's only one child. That would be the daughter, as well. And then the other 23, 4, 8, 6, 7, and other, which involve 2,000 name, but I'm not going to name the children.
Right, it's an ex-girlfriend's father.
Okay. An 11-year-old child in that case, and it's the defendant was the former boyfriend of the child's mother. In the first case, the it was, how old was the child in that one? 13, 11. 11 to 13. The first one, 13. The child was 13 years of age. What I don't have is the information at the time this began in this case, however. Which is referring to the report refers to a date of January 17th, 2019, when apparently this crime was discovered and investigated, and the child at that time apparently was 13.
Between 10 and 13 on
Yes.
the time.
Okay. All right. And then finally, I want to get the indecency with the child case. That's going to be the same child victim as in the second case, 234867.
Correct.
Okay. All right. Again, the agreements are capped at 40 years, up to 40 years imprisonment, 5 to 40 years imprisonment in 33493 and 34867. The lesser included aggravated continuous. And then the child in 34869 is no less than 2 nor more than 10 years confinement in prison. All right. Go ahead. State can go first, or you can yield, and you can go to because you get to go first and last.
I'll yield that, Mr.
Go ahead, Mr. Smith, on behalf of the defendant.
Yeah, I'd like to point out that we have, and I'm knowing this court, as I do, I know the court has reviewed the letters that have been on file from the defense family.
Mm-hmm.
They show that my client, and the people that wrote letters to the court, that he has a very strong family support, that he himself is very supportive of his family and has always been so. There's even a letter in there from prior employer, indicating to the court how reliable and hard-working my client is. There's always at his place of employment, and in fact, this particular person is happy with my client that he's telling the court that he still has a job with and on his belief.
Now, I'm looking at a total of 4 letters, right?
That's correct.
Okay.
And then there is a letter from another person who gave the court a history, a brief history concerning Mr. Simon, that he went to work for a company that went to Iraq, and that my client performed very admirably and honorably with helping the military there in Iraq by doing his work and duties associated with the company, and is asking the court to take all that into consideration, the fact that it's, this person believes, that, now, even after, he pointed out that even after the client returned, from Iraq, and he learned that his grandmother was terminally ill and took the responsibility of caring for her, better than other members of the family, and assisted her with her daily activities. And the recent investigation has revealed that someone who has a prior history and continuously shows that he cannot comply with rules and regulations. This man can't. And we're asking the court to take all that into consideration. I would ask my client, do you have anything you'd like to address to the court? And my client address the court?
Yeah. Put your mask down so I can hear. Thank you. Raise your right hand. Do you solemnly swear or affirm any statement you make during this hearing will be the truth, the whole truth, and nothing but the truth, so help you God? Lower your hand. Go ahead.
I'm not a bank in Virtue Society, and I'm strictly protocol. We have those against me. I can tell you this right. I'm innocent. I'll be for the plea deal to we have filed on probation with instruction and to attack that I'm trying to do.
Oh, thank you. Well, you can't get probation on the aggravated. That's itself, I don't believe. But under indecency, it's let me see the path, please. What else would you like to say? This is your life right now.
So I finally made some mistakes in my life.
I'm looking at I'm trying to pull these things up on Mr. Simon's cases, and that day, that this week, he entered these pleas are not showing up on it. Okay. I know. I only have an Emerson, a Letitia Emerson on the 14th right now in my queue. That's it. There was nothing else on that date. But it's coming. So again, these first two cases we're going to be dealing with, you are charged with the first degree felony, and then you pleaded guilty to the lesser. And then you pleaded guilty to, in that third case, to I just want you to look at this. What? Is that your signature there? That's your signature on that thing? You see your signature? Okay. You signed those documents. You remember going through those hearings? We went through them methodically, one at a time. You remember, and you were under oath. And you signed these documents. I've read the charging instrument, discussed it with my attorney in each case. I committed each and every element of the crimes charged. I am guilty of these offenses and all lesser included offenses against me. I swear all of this is true. So help me God. You said it, right? And we put you under oath. And so today, I'm looking at this pre-sentence report, and you're blaming others, like the children. It's not your responsibility. You want responsibility. Is that what you're trying to tell me today? You did commit these crimes? You didn't commit these crimes. So you lied under oath. You committed perjury when you signed these documents. You've committed perjury. You lied?
I didn't intentionally lie to you. I cleared this with false authentication. I thought that was, I couldn't get there today.
Are you, really? That's the best you can come up with? After we go through all of these procedures and formalities, you're swearing under oath, and you're saying, these are not true, but I'm not lying.
Intentionally lied to you.
Oh, you said under oath, I'm guilty.
That's it. The false authentication.
No, you didn't say any condition. There is no condition, is there?
No,
There is no condition. Did you discuss this with him?
yes,
This wasn't condition.
of course, the court will know. He fled, because Cody refused and takes the plea because he
Oh,
did not,
because he's guilty.
did not want to go to trial and risk what could happen at a trial.
But-
So he chose to go to trial.
Are you saying that these statements that I am guilty under oath do not constitute value and commit him to what he pleaded to under oath? Or else, what we have been doing for 20 years in this room, pleading guilty under oath, has been just a show, a
No.
mockery?
He is relying on the appeal. So the defendant has the right to plead guilty in order to not take a risk at trial.
Well, okay, it also says here, I am guilty of the offense and all lesser included offenses. I swear this is true, so help me God. What does the Court of Criminal Appeals say about that? That you can make these statements under oath and then later at a punishment hearing say, I really didn't mean that. But that's not what you're saying, I hope. So you entered a plea of guilty. There was evidence to support your guilty plea. You knew all of it. And you said, that's what we're going to do. And so I accepted the plea. And here we are. The problem is now you don't want to accept responsibility for what you said under oath, nor what you're charged with in the serious harm to these children. You are accepting responsibility.
Kind of what they were I could guilty or not guilty.
You want to accept, so what you're saying, I want to accept responsibility for what I've done as long as I get probation.
I'm sorry, I'm not saying that. I was
Fine.
I'm saying that.
But you know it's in my choice.
Yes, sir.
Okay. It's in my control. And
So
what else you want to say?
it's shining down because there was no having a reception shot over child when they fixed their gun.
Anything else? Do you know how many cases we've had here? Damage to them. Why is that? Because children can, in many cases, and their bodies can repair very quickly, especially in areas of private areas. And that's also for men, but for children, for girls especially. That's science.
I never sexually penetrated one.
So that's not what you pleaded guilty to. You pleaded guilty here to the lesser included offense. It's guilty to, so help you God, you swore to that. In that case. And in the second case, it's, we've been in there, into herself there. And how disturbing can that be? What you admitted to. Yeah, well, then, there's something about being guilty under oath. Otherwise, this is all a farce. It's ridiculous. It's a waste of time. But you were committed. You do know the difference between the truth and a lie, don't you say? And you had a fine lawyer representing you this whole time. The fact that you've got buyer's remorse on this, it doesn't take away the fact you pleaded guilty under oath. What else? From the defendant?
Nothing like that.
What's that say?
And first of all, to cover the fact that he tried to say this at the pre-sentence report, that he was pleading guilty because of that. Then they asked him, do you want to tell the truth? And then he goes in. I look at this, Judge, and when we get these cases, he keeps saying he's innocent, but he took the innocence of these children. And it bothers me because he gets all this family support and the support they needed from him. The one person who was supposed to protect them, the one person who was supposed to look out for them, the one person who was supposed to stand in the way of anybody doing this to them was the one who did it to them. And their innocence was taken away from them by this man. And when he says he's not a predator, I wonder if you asked these little girls at the time he was doing this to them, what they would consider a predator. Because I think if you looked up predator in the dictionary somewhere, you would find it. One of them would be something that preys on something that's innocent, something that preys on something that he can conquer. And that's what he was a predator. This is not something that we take lightly. This was a plea bargain that he got a really good deal for taking a plea, because he was facing something that started, if I remember correctly, at 25 to life without parole. And here he is facing only a cap of 40. I think we get down to plea bargaining at the end when he finds out he may not get what he wants. And it's something that he's just deciding now, I need to back off because it looks like I might get more prison time than I thought I would, even though I did these crimes. You can tell by the way he lacks responsibility. He doesn't take responsibility for anything he's done, that he doesn't get it, how serious this is, what he did to these children. So we would ask the court to give him the cap, the 40 years on both, and the 10 on the third case.
Anything else? Anything from anybody else?
Okay.
It's my understanding that their agreement was that whatever sentences it says will run concurrent.
Absolutely.
All right, anything else, sir, Mr. Simon, you want to add? If nothing further, I'm going to find in each of these cases you have pleaded guilty voluntarily. You were mentally competent to do so. You understood and appreciated the consequences of pleading guilty. There was sufficient evidence from State's Exhibit 1 admitted here where you swore under oath you were guilty of this crime, and you understood and the elements of it, the ramifications of your plea, and discussed all of this with your attorney that you were satisfied with. There's enough there to support your guilty plea. In each of these cases, we find you guilty beyond a reasonable doubt. And I now find you guilty beyond a reasonable doubt in each of these cases as you have pleaded. A more severe punishment range attached to it. And then I also find you guilty beyond a reasonable doubt in those two cases, as well as 23-48690 in following these agreements, as I have found that there is sufficient evidence to support your pleas to find you guilty beyond a reasonable doubt. You are hereby sentenced to confinement in cause numbers 3, 4, 8, 6, 7, and 2, 4, 8, 6, 9. As I follow this agreement, you are hereby sentenced to confinement in the institution of division of the Texas Department of Criminal Justice to serve a term of 6-9 there. It's not down here.
The 6-9
is indecency.
Yes, sir.
Yeah, it's
the 937.
three cases. It's 33493 and 34867. Again, you are hereby found guilty in each of those. 33493 and 34867, you are hereby sentenced to confinement in the institution of division of the Texas Department of Criminal Justice to serve a term of 40 years imprisonment on each of those two cases. And in 34869, you are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice for several term of 10 years in that case. And these sentences shall run concurrently as the agreement sets forth. The other several cases that you were indicted on, which I think are 6 others,
Yes, sir.
shall be dismissed as a part of this agreement. Do you understand what has occurred today, sir? Yes. What is the price of the loss of innocence of a child? It is a high. It is a high price. It should be the highest. Do you understand? That is. Children are special, and they have to be treated special, and it's up to adults to ensure that their safety and innocence is allowed, and that they get to enjoy growing up without having to recall later that their childhood was a nightmare. Like what obviously must have occurred in this case.
There's